Oyez, 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 all persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Counsel, you may introduce yourselves.
Your Honor, my name is Vincent Bivona. I'm representing the state of Ronaldo in today's trial.
Your Honor, my name is Haley Sink and I represent Hawkeye Pierce.
All right, ladies and gentlemen, good morning or good afternoon. Court's now in session. We're here for the trial of the state of Ronaldo versus Hawkeye Pierce. In a minute, I will ask for arguments of counsel. Before that, I want to note that in accordance with the emergency directives and orders of the Chief Justice of the Supreme Court of Ronaldo, this proceeding is being conducted remotely through the use of the court's teleconferencing system. In accordance with Section 18 of Article 1 of the Constitution of Ronaldo, these proceedings are open to the public via a video link to the proceedings. I ask that everyone mute your microphones unless you are addressing the court, and when you do address the court, please each time begin your remarks by identifying yourself. If the court determines that notwithstanding the court's request, counsel for one of the parties has an unmuted microphone that is causing audio difficulties for the court and or participants in the hearing, the court will mute counsel's microphone but will allow counsel an opportunity to speak when requested. Finally, we've learned through trial and error that the use of conjunctions is sometimes hard to pick up in a video conferencing setting. Therefore, rather than using words like wasn't and couldn't, I ask that you use terms like was not and could not. Okay, as a procedural matter, before we begin with opening statements, I understand that the defendant had a determination to make as to whether to plead insanity as a defense to the charge that has been levied by the state of Ronaldo. Is the defendant able to, through counsel, to advise the court at this time whether the defendant will rely on the insanity defense? Ms. Singh?
Yes, Your Honor. Hawkeye Pierce is relying on defensive insanity today.
Okay, thank you, Ms. Singh. All right, well, with that procedural matter out of the way, Mr. Bivona, I believe it's your opportunity to make your opening statement to the court.
Thank you, Your Honor. May it please the court, counsel, members of the jury. This is a case about a dangerously overprotective father who couldn't stand to see his daughter grow up. This is a case about a man with a taste for violence. And this is a case about a man who, upon seeing an opportunity to act out on his murderous fantasies, took it and carried out the heinous execution of an innocent 22-year-old victim for no other reason than he wanted to. Ladies and gentlemen, as a society, we hold each other accountable for our actions. We condemn those who threaten our public safety, and we demand justice to uphold the value of human life. Ladies and gentlemen, murder is violence. Anger is not insanity. And cold-blooded execution is evil. On May 13th, 2019, the day before Mr. Trapper John was found murdered with gunshot wounds to his torso and to his head, Mr. Hawkeye Pierce was at the local Ronaldo Mall. He was bidding on a job for his engineering company when he stumbled across his 17-year-old daughter walking hand in hand with Mr. Trapper John. An innocent enough encounter, but not for a man like Hawkeye Pierce. No, for a dangerous, violent, and controlling man like Mr. Pierce, the very sight of his daughter walking hand in hand with another man without his permission was enough to set in motion a plan to kill that man. Filled with rage, Mr. Hawkeye Pierce went home that day and launched an investigation into his daughter's personal life. He invaded his daughter's privacy, hacked into her iPad, and began combing through it. Therein, he found some Twitter messages between his daughter and Trapper John. The confirmation of his daughter's romantic relationship with another man fueled Mr. Pierce's anger. This dangerous and overprotective father couldn't stand the thought of his daughter growing up, couldn't stand the thought of not being in absolute control. So what did Mr. Pierce do? Mr. Pierce didn't sit his daughter down and speak to her like any other father would do, like any other rational man might behave. No. Mr. Pierce went online, mapped out the quickest route from his home to Mr. John's home, and loaded his .32 caliber handgun. With the confidence of a man who knew exactly what he was about to do, Mr. Pierce then walked over 6 miles to Trapper John's residence, knocked on the door, and riddled Mr. John's body with bullets. 2 in the chest, 1 in the head. Mr. Pierce then left Trapper John's cold, dead, shirtless body where it lay and went home. Mission accomplished. Throughout this trial, you will hear testimony from several different witnesses, including the lead investigator in the case and a psychologist who examined Mr. Hawkeye Pierce to determine his mental state. I ask that you please listen to all of the evidence carefully that will be presented to you throughout this trial. As the judge has instructed you, it is the prosecution's responsibility to remove any reasonable doubt and prove to you that Mr. Hawkeye Pierce is the man who murdered Trapper John. To prove to you Mr. Pierce intended to commit his murderous actions and was aware of what he was doing as he fired 3 bullets into the torso and the head of Mr. John. Throughout this trial, the defense will likely attempt to criticize the evidence that links Mr. Pierce to the scene of the crime. Additionally, the defense may attempt to argue that Mr. Pierce is insane, not of sound mind, and therefore not responsible for his murderous acts. However, I'm confident that the evidence you will see and the witnesses you will hear from throughout this trial will undeniably link Mr. Pierce to the scene of the crime, place him behind the trigger that ended Mr. John's life, and prove to you that Mr. Pierce consciously and intentionally carried out the brutal execution of Mr. John. Ladies and gentlemen, the decision to act out in a fit of rage, to follow through on violent fantasies, and commit a heinous and violent murder of another human being is not insanity. It's evil, pure and simple. And it's exactly the type of conduct we must condemn as a society. At the conclusion of this trial, I will return to you. And I'm sure that having taken all of the evidence and testimony into account, you will be confident that Mr. Pierce should be held accountable for his actions. And I'm confident that you will uphold justice here today and find Mr. Hawkeye Pierce guilty of the murder of Trapper John. Thank you. Your Honor, I'd like to reserve 1 minute of rebuttal time following the defense's closing. Thank you.
All right, Ms. Sink, I'll be happy to hear from you on behalf of the defendant.
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. Love. It can cause you to do some pretty crazy things. And the love you have for your child is the most important thing in the world. That love eclipses all else, reaches into the core of your being, changes your life. You would do anything for your child. And today, we have before us Mr. Hawkeye Pierce, a man who did. My name is Haley Sink, and I represent Hawkeye Pierce in today's case. Our story begins on a bright May morning when Hawkeye, a loving, single father, business owner, and cornerstone in his community, was out at his local mall bidding on a new construction job to provide for his family. That bright May morning turned dark when Hawkeye saw an adult man walking hand in hand with his underage daughter, Margaret. Hawkeye instantly became incredibly concerned. All he had ever wanted was to watch his daughter grow up to be healthy, happy, and safe. And there in front of him was an adult man who was threatening that. Instead of causing a scene in the moment, Hawkeye decided to go home and access Margaret's iPad, desperately hoping to find anything that could possibly prove him wrong and ease his fears. Instead, he found vile messages sent from that same man to his daughter. Those messages strongly suggested that adult man had already had sex with his underage daughter and was asking her for a, quote, repeat performance. In that moment, Hawkeye was overwhelmed with fear and disgust. He became physically ill, fell to the floor, hit his head, causing everything to go black. The next thing he knew, he was waking up in a jail cell over a week later with no knowledge of what had happened after that moment. Hawkeye stands before you today as a man charged with knowingly and intentionally killing the decedent. The prosecution bears the burden of proving to you beyond a reasonable doubt that Hawkeye knowingly and intentionally killed the decedent. Keep in mind, beyond a reasonable doubt is the highest standard of proof in the criminal justice system, and the prosecution alone bears this heavy burden. If Hawkeye was insane at the time of the decedent's death, he legally cannot have knowingly and intentionally killed him. Hawkeye remembers absolutely nothing about that night after falling and hitting his head, and he was not sufficiently in control of his own actions, so he asserts a defense of insanity. By asserting this defense, we only have to prove to you that it is even slightly more likely than not that Hawkeye was insane at the time of the decedent's death. Our burden is much lighter than that of the prosecution, and we are confident we'll be able to prove evidence of insanity to you here today. Since we are asserting the defense of insanity, we are putting forth two defense witnesses to prove to you Hawkeye was insane at the time of the decedent's death. These witnesses will detail for you the turmoil Hawkeye experienced when he discovered an adult man was taking advantage of his underage daughter. First, you will hear directly from Hawkeye himself. He will tell you how he felt watching an adult man touch his underage daughter. He'll tell you about his reaction to discovering those disgusting messages. Pay close attention to his testimony that he does not remember causing the decedent's death, and furthermore, doesn't remember anything after seeing those messages that night. Next, you will hear from our defense expert witness, Dr. Duke Forrest, a medical doctor specializing in the field of psychiatry. Dr. Forrest completed his residency at the Dallas Institute of Higher Mental Health, and he has decades of experiences accurately determining whether someone was clinically insane at the time of a crime. He will testify that in his professional opinion, Hawkeye was insane at the time of the decedent's death. Dr. Forrest administered a battery of psychological tests, spent over 10 hours evaluating Hawkeye, and reviewed every piece of evidence you will see here today before coming to that conclusion. As you listen to the testimony here today, we ask you to think of the moment Hawkeye discovered those horrifying messages and blacked out. The moment his world turned upside down, and the moment his love and desire to protect his underage daughter from the perverted notions of an adult man completely overwhelmed him. And at the end of this trial, we will ask you to return a verdict consistent with the facts of this case, a verdict of not guilty by reason of insanity. Thank you.
Thank you, Ms. Sink. All right, Mr. Bivona, are you ready for the state's closing argument?
Yes, Your Honor.
All right, as I understand it, you have 8 minutes with 1 minute reserved for rebuttal.
That's correct, Your Honor.
All right, you may proceed.
Ladies and gentlemen of the jury, thank you for your valuable time throughout this trial. As I stated to you when we first spoke, this is a case about a dangerously overprotective father, a man with a history and a taste for violence. This is a case about a man who saw an opportunity to act out on murderous fantasies and took it. This is a case about Mr. Hawkeye Pierce, a man who committed the heinous execution of an innocent 22-year-old victim because he was angry, not because he broke away from reality. Ladies and gentlemen, no amount of love or anger can justify cold-blooded murder. The witnesses you have heard from throughout this trial and the hard evidence you have seen linking Mr. Hawkeye Pierce to the scene of the crime have provided you with facts that undeniably confirm that Hawkeye Pierce is the man who murdered Trapper John, that Mr. Pierce knowingly and intentionally pulled the trigger of his .32 caliber handgun and riddled Trapper John's body with bullets, that Mr. Pierce both consciously planned and purposely executed the brutal execution of an innocent 22-year-old man. Let's review the facts that we have gathered throughout this trial. During this trial, you heard from the lead investigator in the case, Mr. Henry Blake. Mr. Henry Blake has worked at the Worrell County District Attorney's Office for the entirety of his career. He has investigated approximately 40 murders and has had a conviction on every single one of them. This record speaks for itself. Mr. Blake is no doubt a capable investigator. He has the training and experience to investigate crimes and gather the evidence necessary to solve those crimes and bring individuals to justice. Mr. Blake described to you the gruesome crime scene that he arrived at on the early morning of May 14th, 2019. Mr. John's shirtless body lying in front of a blood-stained sofa with 2 small caliber bullet wounds to the torso and 1 to the head. Upon arriving at Mr. John's residence, Mr. Blake processed the crime scene thoroughly and even took the next step in processing Mr. John's computer. Therein, he began to uncover the reason behind Mr. John's murder, to uncover the motivation behind Mr. Pierce's heinous execution of Mr. John. That motivation, revealed through emails and Twitter messages found on Mr. John's computer, was simply that Mr. Pierce's daughter was in a romantic relationship with Mr. John. As a violent, controlling man, Mr. Pierce would not accept that reality, and so unleashed his anger on Mr. John, executing him in a way that he had read about, fantasized about, and finally acted out when he riddled Mr. John's body with bullets the night before May 14th. Now, Mr. Blake's testimony has also revealed to you a load of evidence that investigators recovered from the scene of the crime and from Mr. Pierce's home that links Mr. Pierce to the murder of Mr. John. At the time of his arrest, Mr. Pierce had a .32 caliber shell casing in the right front pocket of his pants. This shell casing was the same type of ammunition used to execute Mr. John. The same type of shell casing found on the floor of Mr. John's apartment. The FBI lab at Quantico confirmed that the shell casing found in Mr. Pierce's pocket and the one recovered at the scene of the crime were fired from the exact same gun. Additionally, at Mr. Pierce's apartment, investigators recovered a receipt for .32 caliber ammunition purchased by Mr. Pierce himself, a target from a pistol range, practice shots fired into the chest and the head of this target, a novel about a trademark assassination shooting pattern, the triple tap, 2 in the chest, 1 in the head. And finally, investigators recovered a Google Maps route, marking the walking directions directly from Mr. Pierce's house to Trapper John's house. All the dots connect. Now, you have also had the chance to hear from Mr. Pierce himself. Mr. Pierce admitted to owning a .32 caliber handgun. Mr. Pierce testified that he hoped he was the one who killed Trapper John. A man who hopes to kill is certainly someone a reasonable person could expect would kill. Together, these pieces of evidence construct a solid and vivid image of what occurred on the night of Trapper John's murder. Upon learning of his daughter's relationship with Trapper John, an enraged Mr. Pierce couldn't bear the feeling of not being in control. So he decided to live out his violent fantasy. Mr. Pierce printed directions to Mr. John's home and loaded his .32 caliber handgun. Mr. Pierce walked to Mr. John's home, knocked on Mr. John's door, and when Mr. John opened it, Mr. Pierce executed him in the way that he had read about. 2 in the chest, 1 in the head. Now, the defense has attempted to convince you that Mr. Pierce was insane at the time he murdered Mr. John. So Mr. Pierce was not aware of what he was doing and therefore should not be held responsible. Now, we heard Mr. Pierce say that he is crazy, but we know that's not true. Mr. Pierce is a smart, educated man. Mr. Pierce is a man trying to escape responsibility. Mr. Pierce knows that the evidence is stacked against him and he has no way out. So in claiming that Mr. Pierce is somehow disconnected from himself at the time he murdered Trapper John is simply the defense trying to game the system and find a loophole. But the evidence does not support this claim, not even by the broadest stretch of the imagination. First, the defense largely relies on the testimony of Dr. Duke Forrest in making this claim. But the test Dr. Forrest relied on in his analysis of Mr. Pierce's mental state is heavily flawed. And Dr. Forrest admits this. Dr. Forrest testified that he graded the mental exam by hand. However, Dr. Forrest also wrote a scholarly article stating that the test he performed cannot be accurately graded by hand. They never come out right, I believe were his words. But what did Dr. Forrest do? He graded it by hand. How can someone who wrote the article about how a test is not accurate if graded by hand, grade that exact same test by hand, and then give an opinion in open court about the findings? Dr. Forrest's testimony is baseless. It's suspicious even, and cannot hold any weight in this trial. Ladies and gentlemen, Mr. Pierce's actions are the actions of a man who is acting with full awareness and purpose. The gruesome nature in which Mr. Pierce planned and carried out the execution of Mr. John was nothing short of deliberate and flagrantly charged with intent. Dr. Potter confirmed this through his evaluation of Mr. Pierce. Upon personally interviewing, interacting, and evaluating Mr. Pierce, Dr. Potter concluded that Mr. Pierce was indeed of sound and competent mind, fully capable and aware of exactly what he was doing when he pulled the trigger and killed Trapper John. Mr. Potter even testified that the pattern of the bullets confirmed, in his expert opinion, Mr. Pierce's conscious and deliberate intent in the commission of this murder. I mean, the pattern was the same triple tap Mr. Pierce had read about, carefully placed bullets. It is unquestionable that Mr. Pierce's murderous acts were carefully planned out, consciously thought about, and purposefully executed. Ladies and gentlemen of the jury, the evidence against Mr. Pierce is overwhelming. The facts show that Mr. Pierce knew exactly what he was doing as he planned and carried out the brutal, cold-blooded execution of Trapper John. The facts show that this is a case of a control freak, a violent man with an unchecked temper who acted out on a violent fantasy and murdered an innocent 22-year-old man out of nothing less than pure anger. Ladies and gentlemen, based on these facts and in an effort to uphold justice here today, I ask that you find Mr. Pierce guilty of the crime of murder. Thank you.
Thank you, sir. All right, Ms. Sink, are you prepared to go with the defendant's closing argument?
Yes, Your Honor.
All right, you have the floor.
May it please the court, opposing counsel, members of the jury. At the beginning of this trial, we asked you to think about parents' powerful and unwavering love for their children and how that love leads parents to do everything in their power to protect those children from the dangers of the world around them, including predatory adults trying to take advantage of them. Hawkeye is a loving father with sole custody of his underage daughter. He's a pillar in his community, a business owner who understandably became incredibly concerned when he saw an adult man trying to exploit his underage daughter. And when he read the appalling messages the decedent sent her about wanting a, quote, repeat of a sexual performance, he became physically ill. He fell to the floor, hit his head, blacked out, not remembering anything from that moment to over a week later. The prosecution is trying to paint a picture of Hawkeye as a cold-blooded, calculating killer, which could not be further from the truth. Hawkeye did not calculate this. He was out of his mind, and he was not in a position to appreciate the criminality of his conduct. In other words, he just snapped, and he went into an involuntary mode of action. His mind blanked. Still, the prosecution's evidence isn't even all that convincing. All of their evidence has direct ties to two biased sources, both of which are directly biased against Hawkeye himself. The first witness you heard from the prosecution is a man who has been dating Hawkeye's ex-wife. And this is the man who collected the evidence for today's case. He refused to look into any additional suspects after taking Hawkeye into custody, and he conveniently lost an FBI report that establishes the credibility of their key piece of evidence. The second prosecution witness, Dr. Potter, has a history of prioritizing convictions over truth. His mind was made up before he ever spoke with Hawkeye. As you heard, he said there has never been a successful insanity defense here in Armadillo, and this will not be the first. So, with this bias firmly in mind, he unsurprisingly did not effectively do his assigned job of completing the court-ordered psychiatric evaluation. He refused to administer any psychological test and he only spent a grand total of 30 minutes with Hawkeye, as opposed to Dr. Forrest, who spent over 10 hours evaluating Hawkeye to uncover the truth. While Dr. Potter claims Hawkeye was as mentally fit as anyone he had ever seen in jail, when pushed further during his testimony here today, he admitted he had never before actually examined anyone in jail. So Dr. Potter is incapable of commenting on how mentally fit Hawkeye is compared to others in jail. Dr. Potter went through this evaluation with the conclusion he wanted to reach already firmly in mind. His biased, haphazard evaluation is as unreliable as his opinion is ill-formed. Now, the prosecution brings up a book found as some sort of evidence Hawkeye had to be rational at the time of the decedent's death. But this book is a fictional airport paperback novel written by a New York Times best-selling author. It is not a manual on how to assassinate somebody. The prosecution relying on this book as some sort of evidence of premeditation is truly grasping at straws. The fact is, when Hawkeye was faced with the grim reality that an adult man was preying on his underage daughter and having sex with her, he just snapped. We have provided you 2 witnesses today to prove this. First, you heard from Hawkeye himself. He told you he previously had recurring psychological issues, and he told you about his physical illness upon reading the messages sent to his daughter and his subsequent lapse in memory and break from reality. Next, you heard from defense expert Dr. Duke Forrest, a published medical doctor specializing in the field of forensic psychiatry. Dr. Forrest completed his residency at the Dallas Institute of Higher Mental Health, and he has decades of experiences accurately determining whether someone was clinically insane at the time of a crime. It is his professional opinion here that Hawkeye was insane at the time of the decedent's death. Dr. Forrest spent over 10 hours evaluating Hawkeye, and he administered a wealth of psychological tests, one of which was the MMPI, which was introduced as exhibit number 6. This exhibit, the results show that Hawkeye has the classic psychotic B, which you see in yellow highlighter here. This proves that Hawkeye is unable to resist impulses and that he is subject to delusions. Dr. Forrest's testimony here today alone proves evidence of insanity, but when coupled with the rest of the evidence you have heard and seen, it establishes that the prosecution has not, and furthermore, that they cannot meet their burden of proof. It was the prosecution's burden to prove to you today beyond a reasonable doubt that Hawkeye knowingly and intentionally killed the decedent. They have not met their burden, but we have met ours. We have shown to you conclusively that Hawkeye was insane at the time of the decedent's death. We now ask you, members of the jury, to think about Hawkeye as you make this decision. A man with the deep-rooted parental instinct to protect his daughter from the perverted and predatory notions of an adult man, and we ask you to reach a verdict recognizing Hawkeye's insanity, a verdict consistent with the facts of this case and with the situation Hawkeye was involuntarily placed in. We ask you to reach a verdict of true justice, which is a verdict of not guilty by reason of insanity. Thank you.
Thank you, Ms. Sink. Mr. Bivona, any rebuttal?
Yes, Your Honor.
All right.
The defense has attempted to discredit the expert witnesses in this case. Now, regardless of Mr. Blake's personal business, regardless who Mr. Blake goes home to at night, the defense has presented no evidence to prove that Mr. Blake did not conduct his investigation properly. Mr. Blake has an impeccable homicide investigation record. Throughout this case, Mr. Blake collected valuable evidence, evaluated that evidence, and that evidence justifiably led to Mr. Pierce being arrested for the crime of murder. It really is just that simple. In any case, ladies and gentlemen, do not ignore the hard facts of this case. Mr. Pierce is as much of an intentional and calculated murderer as there ever was. The law requires you to trust the reasonable conclusions you can logically draw from the facts of this case. So do that. Do justice. And convict Mr. Pierce of exactly what he is guilty of: cold-blooded murder.
Okay, thank you.